Stanley Carlson-Thies is really a remarkable advocate for institutional religious freedom, and is also a great networker. He organizes a monthly roundtable in the Washington, D.C. area of many groups that are interested in freedom of religion, and is someone who is really well known and well respected and beloved for his interest in gathering people together to share ideas, to network, and to think through difficult issues together. Melissa Rogers, many of you have heard from already. She has been speaking at two of our breakout sessions today. Melissa, I apologize for working you as hard as we have today. I imagine we'll pay you double. The joke, of course, is she's here without being paid at all, so this is not a very large offer on my part. Melissa must be much older than she looks, because there's no way that she could have accomplished the things that she has done without that being the case. She's now a non-resident scholar at the Brookings Institution and also has an affiliation with Georgetown University. And until the end of the Obama presidency was the head of the White House Office of Faith-Based and Neighborhood Partnerships, which was a new office or a reconstituted office in the Obama administration, really designed to reach out to religious groups and non-religious groups that are engaged on the grassroots level in trying to improve their communities. And she's someone who has been a problem solver and a consensus builder. The brochures that we have given you, the brochures on religion in the public schools, religion in the public square, religion in employment, really are the brainchild of Melissa. She started these more than 10 years ago and drafted the first set of these and then helped build the consensus around them that resulted in their development and publication through the Museum Institute. And we're really pleased to be launching here at this conference the beta versions of the next generation of those pamphlets. And our hope is that through the museum and their network, we can find a similar broad coalition of people who are willing to sign on and lend their institutional credibility to these being fair-minded and balanced descriptions of pragmatic approaches to solving problems, and also to understanding what people's rights are, what the law is, and how religious differences can be accommodated in ways that are respectful without resulting in violations of the Establishment Clause. Prior to her work in the White House, she was the director of the Center for Religion and Public Affairs at Wake Forest University Divinity School, and also the director before that of the Pew Forum on Religion and Public Life and the General Counsel of the Baptist Joint Committee for Religious Liberty. What you may not know about the Baptist Joint Committee is it's one of the leading religious freedom advocacy groups in the United States, and one of the oldest as well, with work perhaps not under that title, but going back to the founding era. So it is a really remarkable institution dedicated to religious freedom in the United States. Our third speaker will be Alexander Dushku. Alexander, I would like to claim, because he's a graduate of BYU Law School, but he graduated before I got here, and so I wasn't able to inflict my usual harm on him that I do on our more recent vintage students. Alexander also must be much older than he looks, because by appearances he should be a recent graduate, but it's really no exaggeration to say that Alexander is one of the leading practicing lawyers in the area of religious freedom in the United States. He's a shareholder at Kirton and McConkie, and works largely in appellate advocacy, which means not arguing cases before trial courts, but before courts of appeals, state Supreme Courts, federal courts of appeals, and the U.S. Supreme Court. And he has been involved in writing briefs on virtually every important religious freedom case over the last 20 years. And so he's someone who has a practitioner's connection to the real world, something I happily lack, but also a scholar's acumen, which is something that appellate lawyers need as well, because appellate advocacy really straddles the bridge between advocacy and scholarship. There is a very strong scholarly component to good appellate advocacy. So without further ado, I'm just going to turn the microphone over, and we will start with Stanley. And then if there's any time at the end, we might have a few minutes for question and answers. But we're going to let all three presenters make their presentations before we open the floor. Stanley.
So those were kind words of introduction for all of us, and I appreciate that. I'm a coffee-drinking Calvinist, so I can be part of your diversity quotient. So I'm really honored to be on this panel and to speak to this conference, so thank you for the invitation. And I want to talk about religion and sex, or more precisely about how it might be possible to protect at the same time both religious freedom and other civil rights. And it's kind of odd to those of us working in religious freedom that so much of our work these days is about sex, but that's the way the world has turned out, so that's what we have to do. You know, this question of religious freedom and other civil rights involves constitutional principles and legal details, interpretive trends, court precedents, but I'm going to step back from all of that and consider broad trends and strategies, ideas, ways to think about these things and not the details of the law. So instead of a civil rights or non-discrimination approach, which is what we often think about for this, I want to recommend a government policy of pluralism that protects organizations of diverse convictions and practices. So thinking about reconciling religious freedom or religion and other civil rights, these days, it often means disputes about religion and sex, about contraceptives, abortion, sexual orientation, gay marriage, gender identity. I want to remind you, sometimes it's actually still about religion. The Trinity Lutheran case, I think Melissa will talk about. But can a religious organization only hire people of the same faith? Is it possible? Is it right for a faith-inspired organization to get government money and so on? So those issues are still there as well. There always will be tension, I think, between these different rights, but I think one reason why these conflicts seem so intractable is because we often see only kind of an either-or way ahead. Either one side wins or the other one, gay rights, religious freedom, religion is going to dominate everyone or else be put into a box in the corner. But I think a government policy of pluralism, what we already do to a large extent, may show us a better way to deal with these conflicts. So I want to make 4 points or arguments and then end with 2 public policy examples. All right, so 4 and then 2. The 4 points. First of all, civil rights or non-discrimination model is not the only way to deal with these things, and it may not be the best way forward. Point 2, conflicts between religious freedom and these other civil rights are often not disputes about religion and sexual equality, but rather disputes between different worldviews or moral systems. And then third, the religious freedom or religious exercise that needs to be protected is not only individual, but also institutional. And fourth, a public policy that protects the freedom of organizations to be distinctive, to embody distinctive religious and other visions and values, that kind of pluralist government policy is the way to make it possible for us to live together despite our deep differences. So that's my argument, and I'll use those 2 examples at the end. So first of all, the civil rights or anti-discrimination model is not the only strategy and may not be the best way forward. When we think about civil rights movement and the fight against segregation, we see this rightly as kind of an either-or thing. Either we are going to allow bigotry to be expressed against African Americans, or we're going to stop it. So we decided to stop it and to outlaw it. Is that what should be done in these other areas of dispute? If a person or organization, for example, treats a person in a gay marriage or relationship differently than they treat other couples, is this always bigotry that ought to be outlawed the way racism was? So I think there are actually differences in these different civil rights conflicts if we think about it. Consider that our civil rights laws, that in those civil rights laws, few civil rights and non-discrimination norms are absolute, the way the prohibition of racism is. Religion's treated differently than race. Sex is treated differently. Disabilities are treated differently. There are exemptions or accommodations. There's different ways to deal with these things. Just to give a concrete example, you may know that federal civil rights law outlaws religious discrimination by employers when they hire and fire, etc. But the same fundamental law makes it legal for a religious organization to take account of religion when it hires and fires. So BYU, for example, could hire only LDS professors, and that's perfectly legal according to the same civil rights law that says a secular employer cannot discriminate based on religion in hiring. Right? So this is more complex than the question of race. Apparently, not all different treatment is always wrong. So a non-discrimination absolutism, if I can call it that, may steer us in the wrong direction. Our civil rights laws have many exceptions and accommodations to other rights and other realities. Second, conflicts between religious freedom and these other civil rights are often, I think, not disputes between religion and sexual equality, but rather disputes between different worldviews or moral systems. So we say something like this: here's a conflict where there's a religious belief on the one side, and on the other side, a person who identifies as gay or transgender who is simply seeking an education or a job or housing. So naturally, religion should give way to this real instance of injustice. Well, that's one way to interpret it. But actually, both parties in this kind of conflict often have convictions, legitimate convictions, about identity, sexuality, and justice. This isn't just a conflict between kind of an abstract religious doctrine, the way you read the Bible, something like that on the one side, and real human lives on the other. Rather, there are real human choices on both sides of these distinctions. One group of citizens is sure that gay conduct in relationships are morally no different than straight conduct in relationships. So, of course, there shouldn't be any difference in how people are treated in these different kinds of relationships. But, of course, there are many other people who are convinced that there are significant moral differences. That doesn't mean they hate people who are different, but they want to be faithful to what they think God has taught them about humanity. And they're sure that the godly design for marriage and sexuality is one way and not another way. So they want to be true to that by only conducting traditional marriages in their churches, or by having a traditional moral conduct code for teachers, students, and staff in their educational institutions. And they want these distinctive standards not because they're against other people, but because they're for certain beliefs that are legitimate beliefs. And they think they ought to live consistently with those. Now, if the law says that the desire to have a school or church that operates consistently with traditional morality is just a bigoted desire, and then makes those practices illegal, well, then that's the government taking sides on one or the other point of view, right? And the government has done that between these two moral positions, even though it's not wrong or illegal to be sure that God prefers traditional marriages and a biblical standard of sexuality. Of course, that doesn't mean you can oppress other people, but having that view and wanting to live consistently isn't wrong. So is there a way to protect everybody on both sides? That's the question. So in the guise of stamping out discrimination, a policy that just says it's illegal to treat everybody differently no matter what the situation actually suppresses religious freedom, even though the freedom to exercise your faith is a constitutional value. I don't think that's a good way to deal with these conflicts. Third, the religious freedom or religious exercise that needs to be protected is not only individual, but institutional. We've heard that a number of times today. So I want to stress that for a few moments. Individual religious freedom is essential, having to do with you and wherever you are, but it doesn't go far enough. I think the law also must strongly protect the ability of organizations to follow the practices of a religion or a secular philosophy, if we are going to fulfill the American ideal of letting people live consistently with their deep convictions. Well, why should organizations be allowed to be distinctive? Organizations, so think of companies, universities, health clinics, drug treatment programs, and so on, are ways that people serve others, and distinctive organizations are ways to put distinctive views into practice, distinctive way of serving people, a distinctive way of relating to your employees. So that's why the curriculum and community life of BYU Law School is different from Yale Law School. There's a different vision of what living together is, what the law ought to be, the way things ought to be operated. Just to give another example, people in the charismatic Christian tradition expect the power of God to be operative in people's lives in a special way. So when these kinds of Christians created Teen Challenge, that addiction treatment organization, they created programs that utilize the power of the Holy Spirit to help people turn away from drugs and alcohol. So they use the power of the Spirit and not only counseling and medical interventions. That's the way they do things. Teen Challenge puts into practice a particular conviction about how addicts can be effectively helped. Now, if it becomes illegal because of new accreditation or civil rights standards for BYU Law School to keep its curriculum, its honor code, its employment requirements, community life standards, and so on, then the LDS vision of a fruitful life and a God-honoring educational program would be hemmed in and could not give much of a contribution to our society. It'd be illegal to run an institution that way. Same thing with Teen Challenge. Their vision of service, that exercise of religion, would be undermined or eliminated if people said, you can't put religion in a service that you offer to people. Well, let me say a little bit more about why institutional or organizational religious freedom is important. Think of a job seeker who is sure, because of her religious convictions, that it's best when possible, it's not against anybody else, but it's best when possible for a child who needs a new family to be placed with a mom and a dad who are in a flourishing marriage. She would like a career helping children who need new homes. But say the state government has said it will only license adoption agencies that agree not to discriminate based on sexual orientation and marital status in adoptions. Then this person with her legitimate convictions about children and families will find no compatible employer, because nobody like that can exist. Or think of the patient with a very serious illness, a patient who believes that God makes suffering meaningful, who wishes a faith-filled atmosphere in his final days, and who is sure that doctors and nurses should not act to end a life that is not yet ready naturally to end. This person seeks a medical facility that values life and spirituality. But what if only secular hospitals or profit-driven hospitals that don't care about these things exist? Where will this patient be adequately served? When we say our society is diverse in beliefs, that means not just that some people go to church and other people don't. It means that different people seek to live their lives by different standards. So if our laws don't allow organizations, for-profits, nonprofits, to embody different convictions, we're not really honoring the desire of these folks to live faithfully with their convictions. On the other hand, if we do allow for distinctive organizations, with distinctive employment practices, work cultures, distinctive ways of service, then our diverse citizens can find places in which to serve and from which to receive services that fit their religious convictions or their moral values. Well, I'm sure that there are, for example, restaurants where the staff must keep kosher. How else would you have a kosher restaurant? And is it bad to have one? I don't think so. And I also know that PETA, the animal rights organization, requires anyone who wants to be their media spokesperson or a fundraiser to have a consistent vegan lifestyle, which means I wouldn't be welcome there. Is that wrong or bad? I don't think so. It allows them to run a consistent organization. I think we need to let those kinds of things happen. Allowing institutions to be diverse in this way is the way to enable people with diverse convictions and identities to be able to live consistently with their deep desires and faiths. If civil society and the marketplace are diverse, then citizens with different convictions and moral systems will all find places to serve and be served. Then we can live together even though we have a lot of different values. But that's my fourth point. A public policy that protects this freedom for organizations to be distinctive, to embody these distinctive religious and other visions and values. This kind of pluralist government policy is a way to make it possible for us to live together despite our differences. You don't have to force yourself into somebody else's way of doing things. But of course, this isn't a magical solution. You saw that if I hadn't said it. It doesn't make all the conflicts go away. You know, if a religious nonprofit only hires people of a particular religion, then some job seekers who want to work there are going to be turned away. That's just life. And that job seeker may claim that this is wrongful discrimination. The cohabiting straight couple or the married gay couple who come to that adoption agency that only places children with married mother and father families, they may be inconvenienced and even offended that the agency doesn't help them. These are serious conflicts, so I want to say that. But I want you to notice three things as well. First of all, having to look for a different job is one of the most common experiences in life. There are a lot of reasons why we have to go one place or another to find some place that's compatible. Secondly, having to look for another place for service is not the same thing as being excluded from receiving a service, although we may be sorry that we didn't get the service at our place of first choice. In fact, there are many reasons why we all often have to look to one place and not another one for some kind of a service. When is that appropriate, when not? I think we need to think about that pretty hard. Thirdly, the burden of having to look further for service, for employment, is just the burden of pluralism and of allowing our fellow citizens to live according to their own values, not just in their homes, but in organizations that serve in our diverse society. And of course, when there is organizational diversity, that means that everyone at some time or another will find themselves not welcomed by some employer or some store or nonprofit. Certainly in our secularizing society, many people of faith find it difficult to find services and workplaces that they are truly happy with. But while in a diverse society it's inevitable that everyone will encounter settings they regard as devaluing and discriminatory, I think careful government rulemaking can minimize those problems, help us to live together more harmoniously than if we just let everyone and every organization just do whatever. So I want to give two examples of pluralist public policy that help ease the problems when we are diverse and have diverse organizations. First of all, the faith-based initiative or government partnerships with religious organizations. Melissa Rogers worked in that under the Obama administration. I did under the Bush administration. Many religious organizations provide very good services, education, healthcare, adoption, and so on. So it's natural that government often contracts with or gives grants to these organizations to expand their services. That's the way the government gets its good work done often. Now, imagine if that Teen Challenge addiction prevention service got the government funding to provide those services to people who need help getting off drugs or alcohol. Well, now drug addicts seeking treatment would have to follow Teen Challenge's way, which is spirit-filled come to Jesus treatment program, which some people would not appreciate or find helpful. It's not right for people to be compelled to undergo religious discrimination to get a service they're entitled to. Right? So just giving Teen Challenge the money, say, you do all the drug treatment, wouldn't be right. Well, one way to solve that problem is to force Teen Challenge to become secular. Just do medical and psychological treatment, and then nobody will be offended when they come to get your services. But then, of course, nobody would have Teen Challenge's type of services either. And maybe it's the best way to help some people. So the faith-based initiative has a different solution than secularizing the providers. It actually has two solutions. The general solution is that religious organizations can compete for the government funding without suppressing their religious character or eliminating voluntary religious activities, but they can't turn away anyone because of religion, and they can't put religion into the government-funded service. They can offer it separately, but not in the government-funded service. Then you can come, whatever your faith is, you won't be turned away, you'll get a service that doesn't impose upon your own views. So the organization remains religious, but for the person coming for help, they're not compelled to engage in religion that they object to or that's not their own. That's the general solution. The second solution is called indirect funding or the voucher principle or scholarship. You could call it a number of things. When the person seeking the service can choose between different government-funded providers, then a religious organization can offer services that actually do include religion, such as a Teen Challenge addiction recovery program, and that's the Supreme Court said that's perfectly fine. In this indirect funding arrangement, it isn't the government that's choosing to fund religion. It's a person going for help, and they pick a place that offers this kind of treatment instead of another one. In this scheme, which I think is preferable, a person who seeks services that include a religious emphasis can find that kind of service, and the people who want only secular help can find secular help. I think that's the best way to go in our diverse society. So here's a pluralist policy that protects institutional diversity and also individual rights. My second example of what I think is a good public policy is the fairness for all idea. You all know something about that. Fairness for all was first put into practice here in Utah, combining new civil rights for LGBT people with enhanced protections for religious institutions and religious people. And I'm glad to be part of very extensive discussions in Washington, D.C. to achieve a similar fairness for all federal agreement. Just as here, our idea is to create new protections for LGBT people at the federal level, while also creating strong protections for religious institutions and people that have a contrary view of human sexuality. Then Americans can live side by side, even though they differ about these important things. We're sure it's wrong for a gay couple not to be able to rent an apartment, or for somebody to be kicked out of a job simply because she got married to her same-sex partner. But it would also be wrong, we think, to require an Orthodox Jewish school or a Muslim charity to abandon its moral conduct code for employees, for volunteers, and for students. We should find a way to protect rights on all sides. Because we are so divided about marriage and families, for example, I think the only fair and sustainable policy in the area of adoption is to assure LGBT people of their right to adopt. That's what the law is. Just confirm that, but not require every adoption agency, whatever their convictions are, to assist with gay adoptions. Adoption decisions, as you know, are normative questions about children's best interests and what's the best match. And we differ greatly about these things. And on top of that, accepting an adopted child is a major undertaking for a family. And it's more likely that families will volunteer to do this when they are recruited by an agency that they trust and that holds some moral authority with them. So it's quite natural that the way things have happened, private adoption agencies at the moment are very diverse. Some reflect a religion, some are secular, some cater to traditional family values, others are explicitly progressive. I think they should all be able to operate within the law. The government can maintain a list of agencies for prospective adoptive families to consult. It could even require agencies to refer people to another agency or to the government list if their values and special competence doesn't match the person or couple who walks in the door. In this way, the diversity of adoption agencies can best serve the diversity of our society without anyone who is legally free to adopt being restricted from adopting. Well, I think that's what a pluralist policy should do in our country when we disagree about so much and yet should be able to live side by side. The government should protect a diversity of organizations, businesses, and nonprofits, even as it watches out for the rights of individuals. The rights of individuals should not be pursued at the expense of the rights of organizations, because individual rights, like the rights of employees, service seekers, organization creators, can only finally be and completely fulfilled when organizations are legally free to be distinctive. Thank you.
Thank you so much. Good morning, everybody. It's great to be here in Salt Lake City with you and wonderful to be back at BYU. It's been a number of years since I've been able to be out here in this beautiful place that many of you call home, and I'm just thrilled to be here. I also want to say a special word of thanks to my friends and colleagues, Cole Durham and Elizabeth Clark, and the full staff of the center here. I know that many of you are working here with the center, and you appreciate its value in a special way. I just wanted you to know that I've, in my various positions in Washington, D.C., I have seen the center from another vantage point, and it has made tremendous contributions to American public life, the formation of law, policy, and politics with a small p, in the nation's capital. And Cole and Elizabeth and the whole staff are so respected by people of all different parties, faiths, beliefs, and ideologies, and that is a true treasure that has been built up through the years, and is something that of which you are justly proud. And so I just want to thank them for the many contributions that they have made to our nation, and also for the great opportunity that I had most recently to work with them when I was serving in the White House, which was a great opportunity to see Cole and Elizabeth and the whole staff at work in a whole new way. That was wonderful. So thank you to all of them. I also want to say a word of thanks and recognition to so many of my colleagues who are here in the room, so many church state experts, religious freedom experts. I feel like we could have about 20 people up on a panel here and make a really rich discussion. But I hope that what we'll be able to do is have that rich discussion in the latter half hour of this session, because there's so much expertise in this room that we dare not let it go to waste. But let me just turn to the topic that we have this morning, which is a very broad topic. The question is, how broad is religious freedom? It's a great question, and it's one we've been debating since our country was founded, and I'm confident we'll continue to debate for many, many years to come. Because we only have a short time here this morning, I'm going to touch on just some of the key concepts and parameters of religious freedom as we understand it in the United States, mostly focused on the First Amendment, and then open it, and then also touch on the sort of architecture of religious freedom at the federal, state, and local level, and then open it up for further discussion to see what strikes your fancy and what you're interested in pursuing, because we certainly have a rich table before us. As all of you know, the first 16 words of the First Amendment are, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The first clause is, of course, the Establishment Clause, and the second is the Free Exercise Clause. But as Justice Frankfurter said, these clauses represent only different facets of a single great and fundamental freedom. So both clauses, while they have different aims and different pieces of different principles that are operating within them, the clauses are to work together to create religious freedom for all people. Keeping the government out of religion is a core aim of religious freedom. The First Amendment does so in two key ways: by barring the government from advancing or promoting religion on the one hand, and by barring it from prohibiting or thwarting the free exercise of faith on the other. These clauses together create a bulwark for religious freedom, and that bulwark recognizes and respects the dignity and inalienable rights of conscience of every individual. The bulwark recognizes religion as a force that is independent from the state in very important ways. And it helps to ensure that all of us stand before government as equal citizens, no matter what our faith or beliefs. Our system, religious freedom, recognizes that Americans will never be united in terms of our faith commitments. But, crucially, that kind of unity isn't necessary for us to build a strong nation. What is necessary is having religious freedom for all. That is what we can all unite around to build a strong country. And we can come together when we have this kind of liberty across our many differences to promote shared ideals like promoting religious liberty, establishing justice, and ensuring domestic tranquility, promoting the general welfare, and of course, securing the blessings of liberty for all. Well, let's begin by looking at each religion clause individually to dig into a little bit of what it says. The first clause, as we noted earlier, is the No Establishment Clause, or the Establishment Clause. And as I said, it prohibits the government from advancing or denigrating religion generally, and also from preferring one faith over another. Indeed, as the court has said, the clearest command of the Establishment Clause is that one religious denomination cannot be officially preferred over another. And we heard some very eloquent remarks this morning, both from Katrina and from Brett Scharf and from and from Senator Flake about how important that command has been and continues to be to our country. Well, some of the most common Establishment Clause controversies have been over government endorsement of religious speech and government funding that may flow to religious entities as well as non-religious entities. And of course, you have in your handy packet a lot of brochures that dig into these issues in much more detail, and I'm so pleased that we're able to distribute them at this important conference. But just to hit a few of the highlights, we know that under the Establishment Clause, public school teachers and administrators are prohibited from leading students in prayers or from sponsoring prayers by, for example, having prayer on a school graduation ceremony. And in the same vein, the Establishment Clause prohibits the city from erecting a display for the purpose of venerating scripture like the Ten Commandments, although there can be displays that contain religious elements as well as other messages. In some cases, those kinds of displays may be found to be constitutional. And for those kinds of issues, religious expression in American public life covers them in much more detail, and I hope you'll check that out. And I hope you'll permit me just an aside here when I mentioned the Ten Commandments. You may recall that several years ago, a couple of cases were pending at the Supreme Court that involved various Ten Commandments displays. And at the time, before the cases had been decided, everyone was trying to guess how these cases would be resolved. And thinking about the fact that then Justice O'Connor often liked to try to split the difference in church-state cases. So people were speculating about how she might come out on these Ten Commandments cases. And this prompted a law professor, Jack Balkin, to predict that Justice O'Connor would strike down 5 of the commandments and uphold 5 of the commandments. Thankfully, he was wrong about that. But in order to avoid state promotion or sponsorship of religion, the Establishment Clause steps in to reserve the area of religious expression for individuals and religious institutions to shape that religious expression authentically and without involvement from the state. The Establishment Clause also places certain limits on governmental aid that flows to religious entities. Now, this is a very big topic that I think my colleague Stanley Carlson-Thies and I will discuss perhaps at more length in the panel this afternoon when we talk more about faith-based partnerships. But let me just set out a few of the big features of this landscape. It is true, of course, that under our First Amendment, the Supreme Court has upheld the flow of aid to religious as well as non-religious entities in many cases. And so we have long-standing partnerships through the federal government with entities like Catholic Charities or the Salvation Army or World Vision or World Relief to provide secular services for people in need. And of course, as you know, aid flows to various types of religious educational institutions, including those higher education institutions that are affiliated with a particular faith. And there are many types of aid that have been found to be constitutionally permissible and not because they do not have the primary effect of promoting religion. But there are some limits here. And for example, under current law, the state cannot allow direct aid, like funds that flow from government grants and contracts, to subsidize religious activities. And so the state cannot allow a faith-based charity to use government grant funds that it receives, for example, to combat human trafficking. They cannot use those direct aid funds to subsidize a Bible study that the organization also offers. And current law provides that there must not be that subsidization of religious activities with direct government funds, and also that those direct government funds must be separated from activities that are privately funded and voluntarily attended by and offered by a religious institution. Further, the Establishment Clause bars the government from becoming excessively entangled in religious matters and from determining theological issues. And here we can go all the way back to wonderful documents like James Madison's Memorial and Remonstrance, when he said that civil magistrates are not competent judges of religious truth. Very helpful guidepost for us even today. Now, many, when they look at these Establishment Clause limits, will think that these are limits directly on religion. In other words, they think the Constitution is limiting religion itself. And that's actually a mistake, because the Establishment Clause places limits on government's involvement with religion, not on religion itself. In other words, the Establishment Clause is a jurisdictional limit on government's power that in turn protects individuals' rights. The government is barred from promoting faith, and that creates more freedom for individuals and organizations to do so or not as they wish. And here the court has said something really helpful, I think. They said, and I'm quoting, "There is a crucial difference between government speech endorsing religion, which the Establishment Clause forbids, and private speech endorsing religion, which the free speech and free exercise clauses protect." Now, I hasten to add that reference to private speech is not limited to speech in private, but rather describes religious expression attributable to private individuals and groups rather than to the government. So I'll say that again. The court has said there is a crucial difference between government speech endorsing religion, which the Establishment Clause forbids, and private speech endorsing religion, which the free speech, free exercise, and free speech clauses protect. Many also mistakenly view the Establishment Clause solely a source of protection for non-religious people and minority faiths. Now, let me be clear, the Establishment Clause certainly does provide protection for non-religious people and those of minority faiths. It ensures that every citizen stands on equal footing before government, no matter their faith or lack thereof. But this clause also protects the majority faith as well. Well, how does it do that? I would argue that few things are as poisonous for a faith as having the seal of approval of government on that faith. When the state pulls faith into an embrace, several things are likely to happen. Some governmental officials will inevitably pick and choose among elements of that faith. They will deploy the aspects of that faith that seem to help their pet causes, weaponize elements of that faith that seem to undermine the causes that they oppose. In other words, use the faith to attack others. And they will simply ignore parts of the faith that they may find not to be useful. So I think what we are avoiding with the Establishment Clause, we are avoiding a situation where the government can come in and define faith by promoting it, which will inevitably lead toward a kind of funhouse mirror of our faith. And in a way, this will rob faith of its independence and prophetic power. So the Establishment Clause is often viewed as something that's more of a protection for people who want to be free of religious messages. But it's also an important protection for religious people to ensure that the messages and activities that they sponsor are something that truly and authentically reflects their own faith and not some kind of distorted picture that government would present of our faiths. So given the way in which the Establishment Clause operates, I think it's no surprise that many people of faith have been ardent defenders of the Establishment Clause. And this goes back to the founding of our nation, when some of the strongest opponents of government establishment included people of faith like Baptist ministers John Leland and Isaac Backus. Indeed, John Leland said, and I'm quoting here, "Experience, the best teacher, has informed us, that the fondness of magistrates to foster Christianity has done it more harm than all the persecutions ever did." Well, let me turn now to the Free Exercise Clause, that other great pillar of the First Amendment. The freedom to believe is obviously important, but it must be accompanied by the freedom to act on those beliefs. That's what the Free Exercise Clause does. It protects exercise, action. Of course, it's not an unfettered freedom. We don't approve of human sacrifice, even if it's done for religious reasons, for example. But it is nonetheless a broad freedom that protects not only popular religious beliefs, but unpopular religious beliefs as well. And here again, we do not count heads before extending protection. The smallest religious communities' beliefs deserve the same kind of protection as the largest religious communities' beliefs in the United States, and I would say around the world as well. Also, the freedom to exercise one's faith, and this has already been touched on this morning, has a communal aspect that's essential. After all, some religious practices can only be done in groups, like certain forms of prayer for Jewish people. Similarly, religious communities have to have the freedom to form institutions, not only houses of worship, but schools, seminaries, social service bodies, just to name a few. It's in these institutions that we can authentically represent our faith and inculcate it in rising generations. Now we can turn and take a look at what the Supreme Court has done in terms of interpreting the Free Exercise Clause. Up until 1990, the Supreme Court read the Free Exercise Clause rather broadly. It often said that the Free Exercise Clause meant that the state had to have a narrowly tailored, compelling interest in order to justify a substantial burden on religious practices. And this test is the toughest test known in the law, and it's called, by shorthand, called strict scrutiny. Well, that was a standard that was observed, although not always in the way that I articulated it. There were some wrinkles on the Supreme Court's interpretation, but by and large, that was the general rule of thumb that the Supreme Court used until 1990. That changed, however, with the court's decision in Employment Division versus Smith. And in that decision, a court majority said that the compelling interest test, that strict scrutiny test, would no longer be applied if a law was generally applicable and neutral. Then it was permissible, no matter the burden it put on religious exercise. So, as an example, let's think about a no hat rule at public schools. Say there is such a rule, and a Jewish boy wanted to wear a yarmulke. Well, under the compelling interest test, what the school would have to prove is that it had a narrowly tailored, compelling reason for prohibiting a Jewish boy from wearing a yarmulke if that's how it interpreted its no hat policy at the school. So in other words, the school would have to exempt the boy from that rule and allow him to wear the yarmulke to school, or it would have to show that it had a reason of the highest importance to not allow the boy to do so, which I can't even imagine what that would be. But now let's analyze the same case under the Supreme Court's, the rule it developed in 1990, and that is that governmental laws and policies, if they are neutral and generally applicable, are not problematic, even if they put a burden on religious exercise. So using that same example, the court under the Smith standard would look at a rule like that and say, and if a Jewish boy and his family were complaining that he was not allowed to wear a yarmulke under that particular policy, they would try to get an exemption from it. And if the school refused to give the exemption, then the school could argue that the rule was neutral. It wasn't aimed at any religious exercise, and it applied to everybody across the board, everybody in the school. Nobody could wear hats. Now that's a sort of a dumbed down example, but it shows that under the Smith rule, the 1990 rule that the Supreme Court developed, there could be many more instances in which religious exercise was burdened more substantially and without recourse in the law. So when the Supreme Court came down with that decision in 1990, Congress reacted, and through the leadership of Senator Orrin Hatch and Senator Edward Kennedy and many others, passed what has become known as the Religious Freedom Restoration Act, or RFRA, if you will. And that's a federal statute that prohibits the federal government from substantially burdening religious exercise unless it has a compelling reason, and that compelling reason is narrowly tailored to the situation at hand. So right now, while the Supreme Court does not impose strict scrutiny as a matter of law on neutral and generally applicable laws, if there is a federal law that is neutral and generally applicable, but still places a substantial burden on religious exercise, then the federal government still has to show a narrowly tailored, compelling interest in order to justify that burden, or it loses the case. So the federal statutory provisions have become very important in the protection of religious exercise. And we'll talk about that a little more in just a minute. There's one other federal statute that I want to mention right now that's similar, and it's called the Religious Land Use and Institutionalized Persons Act. And it's known by a name that really rolls off the tongue, RLUIPA. And that law protects even not just the federal government, but it prohibits the state governments as well from making overreaching land use decisions where, for example, churches or other houses of worship might be zoned out of an area in terms of locating, or where they might be, they might be subject to unfair zoning restrictions that weren't being applied in the same way to similarly situated non-religious entities. So that law is also a very important part of the free exercise architecture as a statutory matter. That same law protects institutionalized persons, meaning people who are incarcerated, as well as people who are institutionalized in places like state hospitals, and protects their ability to exercise their faith in those settings as well. Well, the Religious Freedom Restoration Act has had a lot of support at the time it was enacted, and still enjoys a lot of support in terms of the general principles that it enunciates. At the same time, there have been many cases that have developed in recent years where even folks who call themselves very, very strong advocates of religious freedom have divided over how the Religious Freedom Restoration Act should apply. And I will only mention a few of these cases right now, but we can talk about them more if you're interested in just a minute. The cases, among the cases that are controversial, include those that have involved the clash of religious liberty, claims for religious liberty under the Religious Restoration Act, and claims for equality based on sexual orientation or gender identity. So today we have often we'll see a situation where you have laws or policies that prohibit discrimination on the basis of sex, sexual orientation, or gender identity, and/or gender identity, and claims by religious individuals or institutions for exemptions from those anti-discrimination protections based on a religious objection to them, maybe based in a belief that marriage should be limited to one man and one woman, and being against same-sex marriage. So we have a number of cases today where the Religious Freedom Restoration Act is being invoked to protect by people who would like to make a religious liberty claim in situations like these, and on the other side being opposed by people who would be defending the rights of equality for LGBT people. So let me be clear here that the fight in this area is not over houses of worship and religious communities and whether they will be able to define religious marriage, even as the definition of civil marriage has changed. It's also not about whether religious bodies will be able to continue to rely on what's known as the Ministerial Exception, which allows religious organizations to make decisions about their minister for any reason, employment decisions about their ministers for any reason, no matter what otherwise applicable civil rights laws may say. And as you may recall, and I think it's already been mentioned this morning, the Supreme Court upheld this ministerial exception doctrine unanimously several years ago. But broadening out from that, when we're talking about schools, when we're talking about the participation of religious entity in government aid programs and non-discrimination laws or policies that are put on those aid programs, sometimes we are seeing the conflict of competing human rights claims in those cases. So these are very important cases to watch. And I'll give you a few specific examples of cases where these issues arise. They include claims by religious organizations that are federal contractors about whether they should be able to turn away job applicants for non-ministerial positions based on the fact that those applicants are married to a person of the same sex. They include conflicts about whether certain small businesses like florists, photographers, bakers may turn away potential clients based on their objection to same-sex marriage and requests by these clients for services in connection with weddings involving same-sex couples. Indeed, as you know, the Supreme Court has agreed to hear this kind of case of this sort during its next term. So cases like these are going to continue to be debated. I cannot tell you now how they will be resolved. We're in the midst of this debate. I think some issues, as I mentioned, are clearly not going to be up for grabs, including a church's definition of marriage, its religious definition of marriage, but other issues are going to be very much up for grabs. And we're in the middle of this very fraught debate right now. Happy to talk about that more if you wish. And indeed, in some cases, we're talking about the clash of free exercise interest versus establishment clause interest, because there'll be an assertion that recognizing some exemptions for free exercise may go so far as to burden people in a way that actually violates the rights of others under the Establishment Clause. So these are, needless to say, complex and challenging issues that we have to face together. Let me just mention about two or three other issues and then throw it open for discussion. And one of the issues that you are aware of is the Trinity Lutheran case that was decided, handed down by the Supreme Court last week. Let me just mention that case. The Supreme Court held in that case that faith-based organizations cannot be expressly excluded from at least some public benefits for which they would otherwise be entitled if they were excluded simply because of their religious character. So this was a very important case that came down, and the Supreme Court looked at it in a way and very importantly determined this area of religious character cannot be a reason for a state to turn down aid to religious institutions. But now we are in the sphere of finding out how broad is that rule going to be. Will it sweep away lots of restrictions that frankly exist at the state level on religious institutions and the kind of aid they can access? Will it sweep away some limitations on prohibitions on religious schools from participating in a voucher program, for example, and many other aid programs that might include religious schools or institutions? Now we are at the point where we are going to see through additional litigation in the lower courts about exactly how far that Supreme Court decision extends. So that's a really important thing for us to watch for the future. Let me just mention a couple of other things and then throw it open for discussion. The other clause of the Constitution that I haven't mentioned yet, but that's very important, is the no religious test clause. You all remember that, and it's in the body of the Constitution itself, where Article 6 says that public officials shall be bound by oath or affirmation to support the Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Thus, this article prohibits the government from disqualifying aspiring office holders due to their religious beliefs or affiliations or lack thereof. This continues to be a very important provision in protecting equality of all people in the United States. And it's come up fairly recently in a actual confirmation hearing of a particular person for the Trump administration, and actually Senator Sanders was boring in on this candidate's particular beliefs about the afterlife, and it sounded quite appropriate for something that you would discuss in a seminary, but not appropriate for something that would be discussed and under examination in a confirmation hearing in the U.S. Senate. So we can't forget that these issues continue to be imported even today. And I would also mention that when we step back and look at the protections for religious freedom, I think it's been implicit in what I've said already, but we not only have the very important guideposts of the First Amendment to the Constitution and the no religious test clause, but we also have federal statutes like the Religious Freedom Restoration Act, the Religious Land Use and Institutionalized Persons Act. I haven't even gotten to many other federal statutes that protect religious freedom, like the Equal Access Act, the Title VII's Non-Discrimination and accommodation provisions for employees in the workplace that very importantly guard against religious discrimination in the workplace and the accommodation of religious practices there. So there are many federal provisions that provide protection for religious freedom, not only in the Constitution, but also in our statutes, and also in our policies, our executive orders, and policy guidance at the federal level. And we can look to, for example, executive orders and regulations that provide protections for the religious identity of faith-based social service providers, something we'll talk about more today. And also protection for religious workers in the federal workplace, protections for chaplains, whether at the Departments of Defense or Veterans Affairs, and also regulations and policy guidance about religious accommodations in the military. At the same time, we have state constitutional provisions that are very important, state statutes that differ a great deal on religious freedom matters, and to some extent, state executive orders and guidance at the state level. So when we think about the kinds of tools that we can use to protect religious freedom, we can look at all these different buckets to see what are the limits on government's involvement of religion, both in terms of ensuring that the government doesn't advance religion and that it protects its free exercise. And I'm happy to talk about any of those in just a moment. But let me just close this portion of my comments with the following from John Courtney Murray. He explained in his essay on civil unity and religious integrity that the First Amendment's protection, and I quote here, the American solution to the problem put by the plurality of conflicting religions within one body politic. And I'll continue quoting from him. He said, these constitutional clauses have no religious content. They answer none of the eternal human questions with regard to the nature of truth and freedom, or the manner in which the spiritual order of man's life is to be organized or not organized. Therefore, they are not invested with the sanctity that attaches to dogma, but only with the rationality that attaches to law. It is not necessary to give them a religious assent, but only a rational civil obedience. In a word, they are not articles of faith, but articles of peace. And I think that we have seen through our country's history that these, however they are interpreted within our own religious traditions, across all our traditions and beliefs, we can embrace these guarantees as articles of peace that help us to live together across our deep differences. And while I know that we face many, many challenges today, including many difficult issues about free exercise and accommodation and establishment, I feel confident that by paying good attention to the values of our founders, that we'll find a way to navigate through this chapter of our nation's history and live toward greater religious freedom for all people, which is, of course, the great promise of our Constitution. So with that, let me just open it up for questions or comments that you might have about any of these issues, or issues that I haven't been able to get to that you want to raise for the group's interest and discussion. I do. Is it on? I'll stay right here. If you want to raise your hand, and I'll just recognize you in place and repeat it from the question from the mic here. Yeah, Katrina? Yeah.
Well, I don't want to go first, but first of all, thank you for a fantastic summary of sort of the basic constitutional principles and legislative enactments. Could you talk for a few minutes about the intersection of both free exercise claims by some of the plaintiffs now or defendants in some of the religious freedom cases, and how that intersects with free expression, free speech claims, because those two threads are coming together in some of these cases involving the cake bakers or photographers, where they feel there's an expressive element, and that being required to bake a commissioned wedding cake or take commissioned photographs is a form of compelled speech against their convictions and beliefs, and how you think those arguments intersect and either support or undercut one another, and which you think would be more persuasive before the High Court.
Thanks. So the question is about the interrelationship of the free speech and free exercise rights, which actually date way back to things that we don't find controversial now at all, like things like the Equal Access Act, where it was based on the idea that school children, as a matter of both free expression and free exercise, should be able to go to public school and as to express their faith in non-curriculum related clubs that met after school if other non-curriculum clubs also used public space after school for those meetings. So there have been many instances in which you can find both the free exercise and the free speech rights being asserted simultaneously. So that is the case in some of these cases that involve religious objections to certain non-discrimination policies. And the case that Katrina referred to is the case that the Supreme Court has accepted to hear next term that involves a cake baker and his business and his objection to baking and selling a cake to a couple a same-sex couple that would be celebrating their marriage. And in that case, he makes the argument that both as a free speech and a free exercise matter, that his objection should be honored instead of being overridden by the local ordinance that prohibits public accommodations from turning people away based on many different grounds, whether it's race, religion, sexual orientation, or gender identity. So here in this case, we have a certain provision that provides protection for LGBT people in the course of a public accommodation, which is a business or various kinds of business and establishments, and a religious objection based on the free speech and free exercise clause. The baker has made that claim. On the other side, the state has said that the baker was not rejected the idea of making this cake before any discussion happened about what the cake looked like or what how it would be designed in any way. So there's an argument on the other side that this is not something that was an actual expression that should be protected, but rather just a public convocation that should be honored. And it's really difficult to tell how the court will come out on this case. I think we'll just have to wait and see. I know that the briefs will further flesh out the arguments, and that's always helpful. But I could not tell you how that case is going to come out. I think we're just going to have to watch. And of course, one of the interesting facets is, as was mentioned this morning, we have a new justice on the Supreme Court. Justice Gorsuch replaced Justice Scalia when he passed. And so one of the questions has been, how will he react to church-state issues? So far, we've seen that Justice Gorsuch, just in the Trinity Lutheran case, at least to my ears, he sounded a lot like Justice Scalia. Now, Justice Scalia also wrote the Employment Division versus Smith case. But we may find that Justice Gorsuch has a more capacious view of his interpretation of the Free Exercise Clause. Stay tuned. Sorry, over there.
I really appreciate your helping us see the broad view and the value of the broad interpretation of something that is meant to protect all of us. And I really appreciate that. My concern in being involved in activism and a lot of discussion concerning religious freedom is the tendency that we have, I think all of us have, in thinking that we're promoting freedom when really we want freedom for our own view at the cost of the freedom of someone who might not agree with us. And looking back over the ways that I've seen different causes and conversations in the level of government and political activism, do you feel that it's kind of in this ebb and flow of returning to that type of unwillingness to see, I want freedom for how I feel, without a willingness to see how what I want impedes and can even be destructive on the lives of other people? And I guess that's something that's alarming to me is even when some of the religious freedom demands for individuals don't even line up with the broad religious creed that they claim to follow, because it is sometimes even dangerous and harmful to entire groups of people. And I hope that there is not, the general direction or the general trend is not furthering that. I'm hoping there's a greater awareness that every religious creed is one of goodness and kindness for everyone. But so many of these cases seem to be ignoring the actual harm that's done when accommodations or services are denied entire groups of people.
Yeah. Thank you. Well, I think an obvious problem there is, when we get caught up in defending, obviously, religious freedom for our religious community and not for other religious communities, that's an obvious problem. And I think we need to keep working on that, because there's a sense in which, it was discussed this morning, I think Katrina and Senator Flake and others, about how important it is that this freedom truly be for all, phase, and none, and not just for people who believe what we do. Or if it's that kind of freedom, then it's not real religious freedom, period. In a more complicated way, the other questions that you raise about competing interests and when accommodations put costs on people who are not the beneficiaries of accommodations or exemptions, I think this is a real area where we need to do a lot of work, because I think sometimes you will see both sides that are squared off. And for here, let me just say a shorthand: those making religious liberty claims and those making claims of equality, dismissing the other side's interests, just looking at our own interests, what we feel is important, and not giving voice to the real interests on the other side of the equation. And that just seems to me not a good way to operate as a basic human being, but also a very bad way to operate in terms of making peace and making peace across our deep differences. if we do not recognize that some people may suffer in some way because of accommodation of our interests, then we're likely going to turn them against our interests because we don't care. We're not paying attention. We're just throwing them under the bus. So I think what's really important, especially in these cases of competing human rights claims, most often liberty versus equality of some sort or another, that we very clearly recognize what the costs are to people on the other side and address that. Now, that doesn't mean that, sometimes costs are there and have to be borne, but recognizing the costs and trying to figure out wherever we humanly can, is there a way to produce a win-win solution here where everybody's rights are respected? That's a beautiful thing when that happens, and we need to look at that very hard. But even when we can't always produce a win-win solution, we need to recognize that there are legitimate competing interests at the table and dignify those interests, or we're not going to be able to hold the country together. Yeah, in the back.
I have a question about that, just kind of dovetailing off of the previous question. The difficulty, and I appreciate your simplifying and diluting all these issues constitutionally, but one of the difficulties is how do you address the conflation of, I guess, what some people view as civil liberties and others view as religious expression. So let me explain. If you claimed a religious expression to discriminate against people who are of a different ethnicity or color, that wouldn't be viewed as a protectable religious expression anymore now. And it seems, or I don't know, maybe I'm wrong on that, but in our history, we went through a time where that was viewed differently than it is now. And so it seems like that same sort of shift is happening in a different civil discourse, but how do we address that, I guess, as religious believers who believe something that, like this woman is saying, maybe infringes on what they feel is their right? So it's a civil right may turn into a civil rights issue rather than a religious freedom issue. Am I making myself clear?
Yeah, no, I get what you're saying. And I think that, my view is if people are asserting a religious liberty right, and sometimes there is a religious liberty right to discriminate or to engage in religious preferences in employment, for example. For example, religious organizations, I just mentioned the ministerial exemption. Religious organizations can make employment decisions regarding their ministers for whatever reason that they choose, without governmental interference, without application of civil rights laws. So there is more complexity there than might admit, than we might think, given the way we see the debates portrayed today. But you're quite right that there has been a progression where there is a religious claim, but that religious claim will often fail. And if it was a religious claim about racial discrimination, that liberty claim to discriminate on the basis of race is going to fail in almost all situations. Now, the question on the table now is, of these various different forms of discrimination, including LGBT discrimination and others, how should the courts balance those? Should the religious liberty right claim be outweighed and thus not recognized as a religious liberty right because the discrimination interest is so weighty? Or should the religious liberty claim be recognized and prevail in the sense of getting an exemption from a non-discrimination rule? And the courts and the legislatures in your own state have been weighing these different ideas and these different values, and they may come out different ways depending on what kind of religious entity is asserting the right and as to whom and when. So there is a lot of complexity there, but you're quite right that sometimes the religious liberty right, the religious liberty claim, I should say, has been recognized as being outweighed by a right not to be discriminated against. And that's the chapter in history that we're living through right now with regard to issues like discrimination on the basis of sexual orientation and gender identity. Wow, I don't know. Let's see, the lady right here.
Thank you. Is that on? You can hear me? Okay. Thank you. It's been very enlightening, and I really appreciate everything you said. I look at this, and I think for myself, I look at what is the proper role of government, and in the Constitution, from my understanding, it says that if it's not in the Constitution, it's reserved to the states to decide. So, and also, my view of the Supreme Court is probably a lot different than yours. There is a matter of interpretation, not legislation. And the Supreme Court has legislated many things from the bench that they have no authority. It's an imbalance of the executive of the three branches of government. So could you address that? Because in the case of, I mean, it is a very critical thing that we stay with our Constitution and that the states keep their state rights. And I see an imbalance here occurring.
Yeah, well, I wish we had a whole nother hour at least to discuss that, because that is a big raging debate about the balance of power between the federal government and the state government, and then within the federal government, the courts and the legislature and the executive. And I'm afraid, I take your point that that's a big, important debate. I'm not sure we can do justice to it in this room with 10 minutes or so left in the time that we have. Okay. 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 Thank you. In the back? Hi.
You mentioned this time of history we're living through right now. I would love it, to the extent you're able, to talk through part of your own experience in the White House, especially during the summer of 2014, when these discussions about weighing religious rights and anti-discrimination provisions in the context of federal contractors came about. There was a lot of letter writing. I'm anticipating that you had a role to play in those internal discussions, and I'd love to hear from your perspective, and this is different from just the courts in their opinions and the legislator, but a lot of what happens is executive action from the White House.
That's
and
true.
I'd love to hear your perspective on, and maybe you personally were involved in presenting the religious viewpoints in what ended up in Executive Order 11246 being amended by Executive Order 13672.
Good job with those executive orders, yeah. No, great question. So yes, this is a great example of the times at which executive power and executive exercises make a big difference. And we can debate, and I'm sure we will in this room, about whether the right balance was struck with that executive order. I know that that's a continuing debate. But instead of getting into that, I'll tell you a little bit about the process, because I think that was important. One of the important things about executive power is that if you're not careful, there's not a lot of input into that arrangement, because unlike Congress that has hearings, or at least they should be having hearings. I hope they generally have hearings on important pieces of legislation. And unlike, the ability to have floor debate on issues, the executive can put out an order without consultation, if that's what they choose to do. I don't think that would be a good practice, and President Obama certainly did not think that would be a good practice. So when he was deciding to put out an executive order in federal contracting that would prohibit discrimination on the basis of sexual orientation or gender identity by federal contractors, that announcement was made that he would be issuing such an order, but that what we wanted to do with a period of time, and it was, I guess, at least a month, if not 2 months, was listen to people about how religious federal contractors should be treated under such an executive order. So we set up what were listening sessions, and some of you came to them. Stanley did. I know others. Mike Levitt was there for some of them. We had, and then we had people from the LGBT advocacy community, both religious and non, come in to talk to us about how religious federal contractors should be treated under this executive order. And it was we did manage that process. I helped manage it with the White House counsel's office, and people throughout the administration heard from all sides about how religious contractors should be addressed through that executive order. In the end, what the president did was retain an exemption that was already in that executive order that President George W. Bush put in, that said that religious organizations could make employment decisions based on religion. And that exemption would continue while adding the protections for sexual orientation and gender identity to this executive order. So what the president did was decide to retain a religious exemption that existed while adding protections for LGBT people. We also said at that time that the Department of Labor, which administers this executive order and the corresponding regulations, should be open to and should hear from religious federal contractors that had concerns and questions in this area and try to deal with those as best they could. As it turns out, there are many fewer religious federal contractors than there are religious organizations that receive federal grants. This executive order did not affect grants at all. So there was a much smaller pool of religious organizations that served as federal contractors, and the issues are still live about how that religious exemption interacts with the prohibitions on LGBT discrimination. Those will continue to be hammered out as they are presented in particular cases. But that was a case in which the president very intentionally authorized a process at the White House to look at the claims on all sides, because he felt that it is important when we talk about religious liberty and religious organizations and religious interests and non-discrimination on the basis of LGBT and otherwise, to be aware of the different views and to try to strike some kind of balance that's appropriate. Whether we got that balance right is up for your debate and your views and consideration. But he did take that approach, and so that is something that we did through the White House at that time. And I'm sure that we will have continuing debates about now whether Congress speaks to these issues or does not speak to these issues. And perhaps we'll get to that matter more extensively in the afternoon discussion. So I think we have to wrap up, but thank you for bearing with me through a very difficult and dense discussion, and one that is sometimes hard to feel a level of comfort with all the issues that we're discussing. But I really appreciate your attention. I appreciate the good discussion, and I look forward to further discussion this afternoon.
I'm grateful to be here with Stanley and Melissa. I've admired both of them for a lot of years. In the case of Melissa, from afar, been aware of her work, and it's great to be here. And it's wonderful that all of you are here and focused on such an important issue, the issue of religious freedom, which I believe is really the centerpiece, the center and most important freedom that exists in the United States. It really is the core of our commitment to pluralism. And it's not just a policy or a platform, it's rather foundational. It's part of the Articles of Peace that allow very diverse people to live together. And so I'm very grateful for those who have worked so hard to put together this conference year after year, and to make it really one of the nation's preeminent gatherings of scholars, lawyers, and citizens concerned about doing the hard work of citizenship to preserve religious freedom. And there is indeed lots of work to do. The cultural conflicts that threaten religious freedom continue to rage. Too many on both sides of the ongoing culture war take absolutist positions that serve only to antagonize and inflame the other side. And yet, in the midst of it all, I believe there is hope. Hope that reasonable compromises and solutions can be found to preserve religious freedom while accommodating often radically different moral visions and visions of marriage, family, gender, and sexuality. In my remarks today, I'm going to sketch out my own understanding of a model for reaching such compromises, which some, including Stanley, have referred to as fairness for all. And then I want to talk for a few minutes about the need for society and the law to reaffirm what might be called the right to gather, the right of believers to gather and establish communities of the faithful. I believe that without recognizing and protecting a strong right to gather for religious purposes, there is very little hope that any kind of compromise can be struck, because religious people and their institutions will face an existential threat. But once that right is strongly affirmed and protected, I believe there is reason for great hope that our current cultural conflicts can be resolved without destroying religious freedom. But first, we need to be clear about where we are culturally. Why? Because, like it or not, culture ultimately drives law and shapes how we understand our rights, and that includes constitutional law and religious rights. It also shapes what sort of compromises can be made as we seek for peaceful solutions to conflicts. We exist in a cultural context, and we can't escape that context, at least not very far. So where are we culturally? Very briefly, and engaging in lots of gross overgeneralizations, we live in an age of secular individualism, at least in the United States, and in an age of growing personal autonomy. Americans are now freer than ever before to choose the life they want without traditional constraints. The vast majority of Americans are wealthy by almost any historical standard. The problem that plagued all civilizations throughout all humanity was starvation. Now our primary problem is too much food. We can access more information than ever before and express ourselves in 1,000 different ways to potentially millions of people. Cultural and legal constraints that once hindered women have rapidly given way to innumerable individual, social, professional, and political opportunities. Many constraints that once limited or guided our actions have been loosened or abandoned. Legal and social constraints on sexual intimacy between consenting adults are essentially gone. Cohabitation out of wedlock childbearing and child rearing are no longer truly frowned upon. There is easy access to birth control, abortion, and divorce. Even biological sex, basically the first thing we ask about when a child is born, is being challenged as a fixed constraint. And as a culture, we celebrate the exercise of such freedoms as an ultimate good. The cultural message is to be your own person, to be true to yourself, follow your dreams, don't let anyone tell you what to do. And not only should you be true to who you are, but you should never, ever stand in the way of others being true to who they are. It naturally follows that one of the worst social crimes for individuals or institutions is to be judgmental or discriminatory. Toleration is owed to everyone, except for those whose beliefs, expressions, or practices are deemed intolerant. And for them, increasingly, there is little toleration and little mercy. Not surprisingly, in this cultural context, support for expansive LGBT rights is high and growing. How could it be otherwise? Especially among young people. The NewsHour program on PBS recently reported that, quote, support among young whites for employment equality for LGBT individuals rose from 84% to 92%. And then it went on to talk about how the trend for other ethnic groups is basically the same. In this context, it is no wonder that every metric indicates that America is becoming more secular and less connected to religious organizations like churches, with all their preaching about things like faith and repentance and obedience and sexual morality. Indeed, the decline of religiosity in the United States may be driving many of these trends that I've just mentioned. But, and this is a key point, despite growing secularism and despite a growing disaffiliation with institutional religion and traditional religious culture are by no stretch gone, and nor are they destined to disappear. Tens of millions of good Americans continue to be deeply religious and connected to a church, synagogue, mosque, or other house of worship. And traditional religious beliefs, including those about marriage, family, gender, and sexuality, are still fundamental to their identities and ways of life. Polling suggests that over 100 million Americans still believe that marriage legally should only be between a man and a woman. So contrary to the fond hopes of some, traditional religious beliefs regarding sexuality are not going away. They are nothing like the theologically bogus arguments that sought to justify slavery or racism. Rather, they are deeply woven into the fabric of all major monotheistic religions. The religious people and religious institutions that hold and live such beliefs will not simply fade away under social and legal pressure. These cultural realities, an increasingly dominant secular culture that is colliding with a smaller and somewhat shrinking but still very durable religious culture, create the possibility of perpetual cultural conflict. But the reality is that most Americans don't want perpetual conflict over these issues. They want practical solutions to the culture wars that preserve religious freedom while appropriately addressing claims for reproductive rights and for LGBT rights. Polls show that people still strongly support religious freedom. They may not know exactly what religious freedom entails, and all of their conceptions may not be legally or philosophically sound, but Americans don't see themselves as suppressors of religious freedom. That's not who they want to be. On the other hand, they also don't want to see themselves or to be suppressors of LGBT rights. They are rather looking for sensible, reasonable solutions that lead to peace. They seem to be saying, in the words of that great philosopher Rodney King, can't we all just get along? But that, of course, is easier said than done. One of the many challenges is that activists on both sides of the culture war have both deep ideological commitments and vested interests in perpetuating the conflict. Both sides are afraid of being marginalized and crushed by cultural forces they don't control. Both sides want to expand or at least preserve the cultural and legal territory they already occupy. And both sides, to be frank, have donor bases that see any slight in their positions as the end of the world. But this conflict also poses serious risks to both sides, whether they want to realize it or not. For religious traditionalists, the risks are fairly obvious, and they are that the secular left will succeed in using the power of government and society to marginalize and silence traditional religious voices and suppress, defund, or even destroy religious institutions critical to the survival of those voices. Those with religiously conservative beliefs about sexuality and gender risk becoming true outsiders in this great nation. And for the secular left, even though the secular left is growing more and more dominant, the risk is that they will win ugly. That is, that they will become what they once claimed to oppose: oppressors, censors, invaders of people's sacred spaces, the destroyers of true diversity, and the generators of new victims with another set of profound resentments. They risk, in other words, winning the cultural war, but losing the cultural peace. In the end, neither side can truly get what it wants without the other. And the irony, as Professor Douglas Laycock has noted, is that both sides want essentially the same thing: freedom to live in dignity and basic equality according to their deepest beliefs and needs. All of this is a prelude to say that there has to be a better way to figure this out rather than tearing our country apart and having perpetual cultural conflicts. Some have referred to this as fairness for all. There are lots of other labels, but what it really boils down to is reviving basic American pluralism, ensuring to the maximum extent possible that everyone has enough legal and social space to live out their deepest beliefs and identities. Based on my personal experiences with these issues, including with the 2015 Utah Compromise legislation, I believe there are 4 elements to a successful fairness for all approach to the conflict over religious and LGBT rights. And there are lots of other things. Stanley and I have been working on some federal legislative issues, but these are four keys that I think are really important. Some of these will be obvious. First, it begins with both sides sitting down and talking with each other. Imagine that. Understanding each other as real people with real lives and real concerns. It begins by building trust and friendships across the cultural and moral divide. It begins with a realization that we're talking with real people, even real people that have very different viewpoints, but people that we can respect and appreciate. Second, both sides must be willing to acknowledge and protect a zone of fundamental rights and freedoms for the other side. Neither side should face an existential threat to its core rights and interests, which means that each side should avoid creating conflicts that the other side must win to survive. Otherwise, there's no room for compromise. Anytime someone is placed in a position of facing an existential threat, that person will simply fight to the death, and there's no way to talk them out of it. Third, both sides should strive to be realistic and sensible about what is a core right and interest. Not everything we want or feel strongly about is truly core. There needs to be some realism and common sense. Each side has to set priorities and avoid considering every slight in a morally diverse society as a serious threat to religious freedoms, equality, or dignity. We can't raise every single thing to the level of a core right. And fourth, when conflicts arise outside core rights, and they absolutely will, both sides should seek for reasonable compromises that seek to accommodate everyone's interests as best possible, rather than ideological purity. Now, this is what I'm trying to capture here, where you have a center that is core, what each side sort of needs to survive, and then there are other things that are important, but which might result in overlap and conflicts. And it's in that area that we have to be willing to strike some reasonable compromises. This is a very pragmatic approach. It's what lawyers and business people do all the time when negotiating settlements or deals, when they know that they can't get everything they want, but they need to reach an agreement for the good of both sides. The goal is a win-win solution, not perfection. When both sides are operating within a fairness for all or pluralism framework, creative lawyering can usually bridge the gap. What creative lawyering can't bridge, are rigid ideological positions that just simply clash. That was the approach we tried to take here in Utah with the 2015 Utah Compromise. That's been criticized on the left, it's been criticized on the right. But when it was all said and done, it worked pretty well. And most people walked away from it feeling like it was something that they could be united around. And it brought some peace and a measure of comfort, especially to the LGBT community, but also to religious people who were deeply concerned about what LGBT rights entailed. Now, I don't want to downplay the difficulty of reaching fairness for all compromises. It's actually exceptionally difficult, even when both sides truly want to get there. And again, Stanley and I have direct experience on this front. You can spend literally hundreds of hours trying to work through these issues. But where there's a commitment, you typically find a way to work things out, where there's a relationship, where there's a desire to end the conflict and figure out ways to live together. There are approaches that I believe can work. But the fairness for all or pluralism approach does face some serious obstacles from both the cultural right and the cultural left. And these are concerns that are basically sort of ideological concerns that we need to get over. On the cultural right, some minimize the obvious mistreatment of LGBT persons that they have faced throughout history. Others acknowledge past mistreatment, but claim that LGBT persons deserve no specific protection in the law because there's no specific problem in the present. It was all in the past, so let's not worry about it. On that ground, they oppose essentially all laws extending rights specifically to LGBT persons, denying not only legal protection, but, and this is often even more important, symbolic legitimacy to a group that has long been discriminated against and that still feels very vulnerable. Further, some religious conservatives see any compromise on LGBT rights as a betrayal of deeply held religious beliefs, and in any event, utter foolishness because the LGBT community supposedly will never honor a compromise. If you simply give them a little bit, they will come back and demand more and more and more, and therefore no stable compromise can ever be reached. These views on the right, which I reject, are a recipe for endless conflict and obviously are serious obstacles to any kind of fairness for all approach. But it's not only the right that imposes obstacles. On the other side, the cultural warriors of the secular left are pressing their advantage at nearly every turn. Once defenders of toleration for diverse views regarding sexuality, too often they are now the enforcers of a rigid new orthodoxy that tolerates only one viewpoint, and that any speech that is outside of that viewpoint is denounced instantly as homophobic or as bigotry. This, of course, is what terrifies those on the other side of the aisle who are concerned about religious freedom. I want to talk about three specific lines of thought on the cultural left that I see as serious obstacles to reasonable compromises. First, as mentioned earlier, many LGBT activists seem to believe that religious traditionalists will simply disappear if there's enough legal and social pressure applied, refusing to understand that tens of millions of Americans of faith are just not going to change their religious beliefs and abandon them about their religious beliefs regarding sexuality merely because of social pressure, and they're certainly not going to magically disappear. If only 20% of the population retains traditional religious beliefs regarding marriage, family, gender, and sexuality, we're still talking about 64 million people. Are we prepared to ostracize and legally suppress that many people? America just doesn't tend to do that sort of thing. Second, and even worse, is the repeated accusation that deeply held religious beliefs regarding marriage and sexuality are really nothing more than bigotry akin to racism. And this is unfortunate. Rarely do we hear LGBT activists publicly say, and there are some that do, but not enough, say what Justice Kennedy accurately acknowledged in the gay marriage decision, that informed people of goodwill can sincerely and validly hold different beliefs about marriage and sexuality. Instead, there is a pernicious equating of traditional moral beliefs with racial bigotry. In other words, with evil and with a dark ignorance. That view certainly makes it difficult to reach compromises, both because you assume that such beliefs will simply collapse of their own evil and stupidity, and thus shouldn't be legitimized through legal protections, and because you assume that the people you're negotiating with on some level are themselves bad, or at least dangerously ignorant. It makes for a great deal of difficulty in negotiating if you're coming at this from a view that your opponents are just simply bigots. These two erroneous ideas are tied to a third one that makes compromise difficult. It's the notion that when people of faith gather under shared religious beliefs, commitments, and standards, that they are actually engaged in invidious discrimination. This view lies at the heart of attempts to cut back on the right of religious organizations and schools to hire people who truly believe in and live their religion. It lies behind the effort to shame, defund, and deny accreditation to religious schools that have traditional codes of conduct, and even to deny employment to the students of such schools based upon the religious beliefs of the schools that they attended. Not only does this view make it extremely hard to reach fairness for all compromises, it fundamentally threatens, I believe, the very heart of religious liberty. So let me explain that in conclusion. In Matthew, Christ teaches that where 2 or 3 are gathered together in my name, there am I in the midst of them. Ezekiel tells the children of Israel that the Lord will gather you from the people and assemble you out of the countries where you have been scattered. And Mormon scripture speaks of gathering a worthy people to a new Zion, where the pure in heart can live in righteousness and peace, and where even God can ultimately dwell among them. There is, in other words, within Christianity, Judaism, Islam, and nearly all other religions a fundamental need to gather with the faithful. It is not peripheral or incidental or merely some nice thing that religious people do. It is inherent and basic to most faith traditions. This compelling need to gather was a critical driving force behind the colonists who settled America, many of which were denied the right to do so in their native lands. The Puritans of Massachusetts, the Quakers of Pennsylvania, and the Catholics of Maryland all sought a place and space for their religious communities to gather and live in peace. To take just one example from this early era, while bound for America, Governor John Winthrop preached a famous sermon aboard the Arabella in which he described the Puritans of Massachusetts as a gathering of fellow members of Christ. Justice Brennan captured the vital importance of religious communities in his concurrence in Amos, and here's what he said. For many individuals, religious activity derives meaning in large measure from participation in a larger religious community. Such a community represents an ongoing tradition of shared beliefs, an organic entity not reducible to a mere aggregation of individuals. This is what Stanley was talking about earlier. Determining that certain activities are in furtherance of an organization's religious mission and that only those committed to that mission should conduct them is thus a means by which a religious community defines itself. In short, it is impossible to speak of religious freedom in any coherent way without acknowledging that people of faith have a fundamental right to gather and govern their religious affairs. And this right extends beyond gathering to worship and participate in religious services on holy days. It must extend as well to a reasonable and robust degree to the right to form other organizations such as religious schools and religious charities where believers can live out their deepest faith commitments. Let us be clear. Without this right, there is no meaningful religious freedom. And inherent in this right to gather with the faithful is the right to determine who constitutes the faithful. This is fundamentally a theological matter that cannot be decided by reference to secular logic or law. It is not a matter for the courts. As Justice Brennan recognized, it is a matter of religious self-definition. It is not for the state to establish religious standards of religious purity or worthiness or faithfulness. As Christ might have put it, it is not for Caesar to decide who is truly gathered in my name. To denounce this fundamental element of religious identity and self-definition as merely discrimination is not only inaccurate, but ultimately dangerous. The insistence that anti-discrimination laws and norms must apply within vital religious precincts is a direct threat to religious freedom at its most basic level. For if the state can control who participates in a faith community, it can ultimately control the nature of that faith community, including what it believes. No one who believes in the separation of church and state at its most basic level should support that end. In sum, and in conclusion, while non-discrimination laws and norms are a vitally important part of the American commitment to legal and social equality, they have always had their limits. Religious organizations, religious schools, and religious charities are vital places of gathering for the faithful, and thus differ in basic ways from quasi-public commercial enterprises operating in the marketplace. Much as non-discrimination laws do not and should not seek to regulate personal and intimate relationships, they likewise should not improperly intrude upon a religious community's right to gather for religious ends. I believe that a strong and unequivocal affirmation by the secular left and by the LGBT community of this fundamental right to gather would go a long way toward calming fears and allowing fairness for all, pluralism type compromises to move forward. Thank you.